Our chief legal analyst, Khalif Rhodes, to break this down. We know separation of church and state. We know there is precedent with this with Stone versus Graham, but we've also seen Kennedy versus Bremer School District with that high school football coach there saying, well, that's okay because that's tradition. Khalif, where does it stand?
Take me back to law school. I am a fan of all those cases you just pumped out for sure, and tracking them as a former law school professor. These type of cases I love to look at. First Amendment, you're not just talking about speech. You're talking about right to petition, assembly, freedom of the press, but you're also talking about freedom of exercise, right to do your own religion and not have someone interfere. Basically, we're saying keep your hands off of our speech, our ideas, and our religion, and off of other people's, because we have inalienable rights. These inalienable rights, they're rights that can't be taken away and shouldn't be taken away. And so if you are saying that, speech, religion, those are one of them. And so this one, in law school, they talk about these nativity scenes, talk about Bibles, prayer in schools, and now the 10 Commandments is coming back, and it was one that was there before. I think this ruling is dead on with what tradition has said, is that it can't be an intertwining. Specifically, the Lemon case is the one that I would point people to look at, because they give you a three-pronged test. Is it secular in nature? Is there any type of heavily intertwining or commingling of the government? Have they attempted to intertwine themselves so much that they can't be disconnected? And are they promoting something that is religious in nature and discrediting other religions? And I think in this, you check all three boxes.
Okay, we know that President-elect Trump has favored maybe getting prayer back in schools. So where do you see this going? Because I have a feeling if they were to appeal this decision and take it to another circuit court, I've heard that it might be down in New Orleans, which is a very conservative court down there.
100%.
Could this be overturned? And where do we even see this going beyond once Trump gets in office? Could we see some Supreme Court issues with this?
I love everything that you're saying there. So a couple things. This case, like I tell every client, is a 50-50 shot. You walk in with the facts. I can't make the facts. All I can do is present the argument, and hopefully a judge will be able to buy what I'm saying, specifically when you're not talking about jury trials. And so here, a district court judge, U.S. district court judge, made this decision. Now it could go to the Court of Appeals for that circuit. They'll make a determination. And yes, likely this will go to the Supreme Court, like the one that you mentioned about the coach that was praying on the field. That case took 5-6 years to make its way through the system, got sped up a little bit. I see this one, again, going before the Supreme Court. I think this court is ripe to hear these type of cases. However, I don't think the history is on their side to be able to say that now you can bring prayer or something like that back, because the law is the law. I mean, that Lemon case has been on the books for a long time. You're talking about Roe v. Wade type of time frame. And so to overturn something like that, I think you would need to have a monumental shift from the folks that are on the bench now, specifically some of these strict constructionalists that look at the letter of the law, and this is clear.
I know we're tight on time, but I just want to ask, because you mentioned going back to Roe v. Wade, because we thought that prior case law would show us and the Supreme Court would rule on precedent. We saw that kind of a race with Roe v. Wade. So is this another chance where, even though we know the precedent is there, we'll see what happens?
I'd say you'd have to see what happens, but let's look at what the judge said here. This law is unconstitutional on its face in every application. I think the Supreme Court would say the same thing.